all rise. We would obey. Please be seated. We will as well.
Yes, Mr. Edwards.
Good afternoon, Your Honours. The topics that Madame Mathieu and I will be speaking about for the rest of today and possibly trickling into tomorrow cover broadly 5 subjects. I'm going to start by addressing you on matters of the credibility of some of the most important prosecution witnesses. Madame Mathieu will then respond to OTP submissions regarding crimes against humanity and specifically persecution. I then will cover the 3 main crime bases, crime sites in order: Kudumen, Bindisi, Mukja, and then Delej. We'll attempt to answer your honours questions at natural points as much as possible.
Can I just say, Mr. Edwards, it was pointed out at the end of Mr. Leitch's speech that he spoke at the rate of knots.
Yes.
And I see your fellow counsel nodding. Could you, I think, for the purposes of the French and Arabic interpreters, not go quite as fast, please? Yes. And in particular, when Mr. Leitch threw in, and that's the answer to question, whatever it was, I had to go back at the transcript and look at which question he said.
Well, yes. Miss Guillou is behind me, and she will kick me when that's required. Your Honour, there were some prosecution witnesses whose credibility was not challenged by the defence in this case. Other witnesses, there are a number of eyewitnesses who were cross-examined on the basis that they were likely mistaken about what they saw or heard, rather than on the basis that they were, on our case, deliberately lying. There were, however, a number of important prosecution witnesses who were cross-examined on the basis that they were not telling the truth, that they had come before Your Honours to lie about what they knew about Mr. Abd Al Rahman, for example, when they suggested that Mr. Abd Al Rahman was also known by the nickname Ali Kusheb, and about acts and conducts in 2003 and 2004. Questions of reliability, questions of credibility of OTP witnesses, that's dealt with in detail in our final brief. But I'll start by making a few introductory remarks, as much for Your Honours as for the public, if I may, about witness credibility, because it really is extremely important to this case. In criminal proceedings, every element supporting a charge must be proven by the prosecution. The prosecution bear the burden of proof. The defence need prove nothing. Obviously, when facing serious charges, it's important for the defence to at least attempt to carry out its investigations and, where possible, call rebuttal evidence. But as a matter of law, the defence do not need to do so. Mr. Abd Al Rahman, his defence, could have just sat here at the close of the prosecution case and told Your Honours that we had no intention of putting on a defence. It bears repeating and highlighting today, as one would in every trial, even a case tried by a bench of experienced, highly experienced judges, that the standard of proof is a high one. To convict a person accused of a criminal offence, you must be satisfied of his guilt beyond reasonable doubt. In some jurisdictions, it's expressed as a requirement that the trier of fact must be sure of an accused's guilt. This is the most fundamental principle of a criminal trial, and indeed it's enshrined in Article 66 of the Rome Statute. And when Your Honours do retire to consider your judgment in this case, we respectfully urge you to ensure that the burden and standard of proof remain at the forefront of Your Honours' minds. We're confident, of course, that it will be. Your Honours' chamber has a broad discretion in assessing matters of credibility and reliability of witness evidence. And you will give appropriate weight to that evidence individually and taken as a whole. Your Honours can rely on a myriad of relevant factors when considering questions of credibility and reliability, including corroboration, lack of corroboration, a witness's personal involvement in the events, when there are issues of a risk of self-incrimination, issues relating to possible bias or animus against an accused, and other motives for not telling the truth. You'll look at questions of consistency, contradiction, internally and with other witnesses' evidence. And you will bear in mind, to the extent you can, issues such as the witness's attitude during their testimony, their demeanour. All of these are matters that will impact on what weight you place on a witness's evidence. Item 31 in our list of authorities, I cite to the appeals judgment in the Gujolo case, 27th of February 2015, and I paraphrase what's contained at paragraph 168. The evidence of a witness in relation to whose credibility the trial chamber has some reservations may be relied upon to the extent that it is corroborated by other reliable evidence. However, there may be witnesses whose credibility is impugned to such an extent that he or she cannot be relied upon, even if other evidence appears to corroborate parts of his or her testimony. That's the end of the paraphrasing. Even an holistic approach of the entire evidence cannot erase a significant lack of honesty of some witnesses. There will be occasion when even approaching an holistic approach, it will not be possible to overcome issues regarding or issues of a witness's lack of credibility or reliability. And we say that is particularly important when it comes to witnesses that have come to be described broadly as the insider witnesses. There are also a number of witnesses, 7 I think, OTP witnesses, who we say must be approached with a great deal of caution because of lies that they told during other judicial proceedings, and here specifically I'm talking about asylum proceedings. And we say that that casts serious doubt on their overall credibility. Your Honours raised that as a question for us. It's question 24, and I will come on to it a bit later. Where witnesses' demonstrated lack of credibility really comes to the fore, Your Honour, it is in those situations where theirs is the only evidence going to a particular evidential point. And we will submit that where the most non-credible witnesses have provided uncorroborated evidence of an event or a feature of the OTP's case, Your Honour's chamber should reject that evidence. Now, let me make it clear. I'm not suggesting that corroboration is a legal requirement. It's not a requirement as a matter of law when evaluating any and all witnesses' evidence. In some domestic jurisdictions it is, but not before this court. But a trial chamber here may find, in the specific circumstances of a case, that corroboration of a particular witness's testimony, or part thereof, is needed for the trial chamber to be convinced of the evidence's reliability and credibility. And that point is made abundantly clear in the Kilolo appeals judgment, which is at item 35 of our list of authorities, paragraph 1084. So for the next few moments, I'll be making submissions on the credibility of the evidence of two key witnesses relating to Kudum and Bindisi, starting with P0878. This was a witness who was by no stretch of the imagination an impartial, neutral, objective witness, demonstrating that he had come to court to try his best to provide an honest account of what he saw and heard. Your Honours may recall the extent to which he demonstrated the most profound animosity towards Mr. Abd Al Rahman. And indeed, Your Honours may recall that lead counsel even had to raise a complaint before Your Honours about his, not just his animus, but his aggressive behaviour directed against the accused. It would be hard, we say, to think of a less measured, less moderate witness. And we say that his only objective in coming to court was to stick in the knife and to twist it. His objective was to divert attention away from himself and from his own obvious criminal responsibility in the events of Kudum and Bindisi. His evidence must be treated with great caution for two reasons. First, because he was clearly a guilty accomplice witness himself. Not, can I be clear, not an accomplice of Mr. Abd Al Rahman, but an accomplice to the murderous Janjaweed in Kudum and Bindisi. We're not saying that just because a witness is an accomplice witness, that his or her evidence should be disregarded. It's not per se unreliable, but it's always important to give careful consideration to the circumstances in which accomplice evidence has been given. And here I rely on, again, Kilolo and the Taganda appeals judgment at 35 and 37 on our list. Sorry, in Kilolo it's paragraphs 1531 and 1535. In Taganda, paragraph 734. But the feature that demonstrates beyond a shadow of a doubt that his evidence is so unreliable that it must be disregarded wholesale is the fact that he dishonestly denied bearing any criminal responsibility. He was an accomplice who dishonestly and frankly implausibly denied being an accomplice. And there are a number of features of his evidence that came from him and from him alone. It was that witness who memorably described the Janjaweed chasing women and men just like a dog chasing a rabbit or any wild animal chasing its prey. At paragraph 110 of its brief, the prosecution state that the government of Sudan provided food for the horses of the Janjaweed and Thoraya phones citing alone to P08, witness 0878 as the source of that evidence. Similarly, when the OTP in their brief assert that Ali Kusheb was in command of the Agids and the Umda present at Kuduman Bindisi, and that P878 saw Ali Kusheb blow a whistle to summon 15 to 20 of his Ogada to give them orders, and saw him override their objections. This is at paragraph 154 of the prosecution brief. They cite to P0878 exclusively. It's P878 who is the only one to testify having heard Ali Kusheb make reference to a big celebration that would be put on in Garcilla by Governor Jafar Abd Al Rahman, and that afterwards the new direction that we will take will be decided for us to carry out our program, paragraph 178 of the OTP brief. And it's P0878 who is the sole source for the prosecution's reference that Ali Kusheb issued orders to the PDF officer Hasabala at paragraphs 193 and 356. Similarly, upon reaching Niala, the order given to soldiers to move forward, to move towards the village, the order to Hasabala to move behind him, sole source, 878, a very important witness for the prosecution, Your Honour, and yet untrustworthy, unreliable, incredible. Importantly for the issue of rape, I'm going to come on to rape a little later, but Your Honours will remember that in the evening, after the first day of the Kuduman Bindisi attack, Ali Kusheb was said to have congratulated the Agids under his command, and you'll recall the words that he said, they had taught the enemy a lesson the enemy will never forget. The evidence of Ali Kusheb scolding Hasabala for taking too long with his assigned task, paragraph 371 of the prosecution brief. And I mean, there are so many examples I could give. I'm not going to take up too much time, but at paragraph 353 of the prosecution brief, Ali Kusheb's words, "I will kill whoever I want and I leave whoever I want to leave." There's a sole source of that evidence. It's P878. At paragraph 438 of our brief, we deal with the evidence of P878, hearing, so it is said, Haroon's words at a public meeting. If you don't give back the property, you will be killed, you will be raped. This is relied upon in the prosecution's brief at paragraph 388. Crucially, P878 is the only witness to testify about those words. Why is that so important? Your Honours will recall that you relied fairly heavily. In any event, you relied on those words having been spoken in public and in the presence of Kusheb, when finding that he could be fixed with prior knowledge of the possibility of rape being committed in the future. P878, uncorroborated, alone. Similarly, paragraph 389 of the prosecution brief, 878 is the only witness to give evidence of a particular Janjaweed leader discussing the acts that they had committed against women that day, and speaking of his perception of women in those villages and how they were aggressed and raped. Our challenges to 878's evidence as an insider and an accomplice are set out in detail at paragraphs 117 to 120 of our brief, and we won't repeat them here. But he was not a credible witness. He was an untruthful witness, and all of that uncorroborated evidence we would ask you to reject outright. Another of the important Kudum and Bindisi witnesses is P921. He also, utterly devoid of credibility, we say, like P878, an accomplice, a man with blood on his own hands. And we set out our challenges to his credibility at paragraphs 122 to 125 and at 386 to 398. Another witness whose interest in testifying before Your Honour's court was not to tell the truth, not to provide an honest and objective account of what he saw and heard. He testified principally to make money. We say that he baited his hook with a entirely false story about Ali Kusheb as being a leader of about Ali Kusheb as leader of the Janjaweed. He cast his line, and the OTP swallowed it. 921 knew full well when he made first contact with the OTP that there had been a warrant out for Mr. Abd Al Rahman under the nickname Kusheb. And his denials about that were so clumsy. They were unconvincing, but above all, dishonest. Given the very real doubts about the truthfulness of his evidence, Your Honours, what he says about his involvement, what he saw, what he heard of Ali Kusheb in the events of Kudum and Bindisi, must be treated with caution and with bucket loads of caution. Anything of which he is the sole witness to must be approached with a great deal of skepticism. He is not deserving of the slightest benefit of the doubt. Some examples. In the prosecution brief, he cited as the source for evidence of murders in Nearly, including the memorable evidence of people, including children, being thrown into burning houses. And this is at paragraphs, for example, 274 and 366 of the prosecution brief. And then in Kudum, paragraph 275, allegedly seeing Ali Kusheb order his forces to shoot at 64 civilians in shackles, including women and young children, but also seeing Kusheb himself shooting. I pause simply to note that this evidence of Ali Kusheb ordering or shooting at people, including women, is quite inconsistent with those witnesses who state that Ali Kusheb directed that women not be killed. Regarding evidence of rape, and I want to stay in open session, Your Honour, so I'm going to be a little bit oblique, I'm afraid, but Your Honours will read in paragraph 332 about certain assistance that P921 says he provided. He's the only witness to talk about this. Very conveniently, you may think. It's not a feature of his evidence that could be easily corroborated, and of course, it wasn't. And we submit that he made it up, knowing how difficult it would be to challenge such uncorroborated evidence, whilst knowing just how self-servingly it put him in a good light. Why would he want to do that? To counterbalance the other evidence tending to demonstrate his own culpability for crimes in Qudum and Bindisi. Some of his evidence of the events in Qudum and Bindisi was corroborated by other witnesses. We accept that. But the main eyewitnesses of Ali Kusheb's purported involvement in the crimes there are all as untruthful as each other. The two witnesses I've spoken about, and also the witness with the code P1021, are all deeply flawed, deeply dishonest witnesses. And we set out in our brief, I'll give you the references in a moment, but the paragraphs in our brief addressing issues of the credibility of P1021 as well. All had strong motives to lie about Ali Kusheb's criminal responsibility. All had good reasons to want, desperately, to distance themselves from their own guilt, to distract by heaping the blame on the man already under arrest and so conveniently already in the frame. I turn from Qudum and Bindisi now to some of the witnesses whose evidence is not credible relating to the events in Mukhjar, and I'll start with P905, the witness who just happened to be absolutely everywhere, the witness who saw everything, always in the right place at the right time. Issues of his overall credibility were dealt with in our brief at 133 to 136. Your Honours may recall, in terms of his demeanour, just how markedly different he was under cross-examination to how open he was when being examined in chief by the friendly prosecution. I don't say that to disparage the prosecution at all, but in his own mind, they were on his side, he was on their side. You'll recall that this was the witness who was shown the video, the Aqsa Amsa video, the singing members of the Sunnis Armed Forces. And yet, despite that, even, he persisted in his untrue testimony that this was a slogan that was somehow unique to Ali Kusheb and the Janjaweed. We also address witness 905's credibility, or lack thereof, in paragraphs 456 to 464. The OTP attempt to explain his credibility issues away in their brief at paragraphs 187 and 232, explaining away his implausibilities and the incoherent features of his testimony. And they try to do that by reference to particular personal characteristics. I won't go into those now because I do want to stay in open session. They reference his protestations of his having been in fear at the time that he was with Ali Kusheb in Mukhtar. But those explanations are utterly belied by the fact that when he had the opportunity to distance himself, having seen what he saw in Mukhtar, to flee, he didn't. He stayed. And indeed, he remained in the company of criminals and came to give evidence about events in Delej. He too gave extremely incriminating evidence, wholly uncorroborated by other witnesses. In the OTP's brief at paragraph 188, the witness spoke of Kusheb issuing direct orders to an SAF staff sergeant. This is crucial evidence for the prosecution. They rely on it to demonstrate Kusheb's power to issue orders to the SAF. He was the only witness referred to, cited by the prosecution, testifying about the events mentioned in paragraph 25 of the OTP brief. Another example of how this is a man who just happened to be everywhere and saw everything. And he saw everything. He overheard everything. All incredibly convenient, we say. He was the only witness cited by the prosecution to give evidence of an incident when 5 captured men were brought before Ali Kusheb and were then met with the response, "Why did you bring them to me? I didn't say bring me anyone. I said execute the operation straight away." And thereafter they were taken away and killed. The order of Ali Kusheb telling his forces, whenever you encounter a man, you have to kill him. An important witness for the prosecution to establish Ali Kusheb's role, responsibility, power over his men to issue orders. But, once again, uncorroborated in respect of much of his testimony. Your Honours will recall there was one witness who asked to be given the opportunity to dress properly before being killed. This is relied on by the OTP at paragraph 433 and the LRV at paragraph 227 of their brief. The only witness, uncorroborated. And the only witness to testify about a particularly memorable and horrific account. And again, I want to stay in open session, so I will be oblique, but it's referred to in the OTP's brief at paragraphs 436, 454 and 55, 488. When Your Honours go back to read these paragraphs, you'll know exactly what I'm speaking about. But testified to by only this one discredited, deeply partial, and deeply hostile witness. We say that 905 was so transparently desperate to see someone, anyone, any Sudanese authority figure anyone associated with the tormentors of the Four population convicted and punished by this court. That person happens to be Mr. Abd Al Rahman. And so that's why he's 905's target. P 129 also gave evidence of the events at Mukjar police station. A lot of his evidence also wholly uncorroborated. At paragraphs 234 and 237, the OTP refers to his evidence only in support of certain derogatory and insulting terms directed by Ali Kusheb towards detainees at Mukjar. Insults such as sons of dogs, nujus, abids. A remarkable feature of P129's evidence is that he said he didn't actually know what abid meant. And we submit that calls into question the likelihood that he would have remembered the word in the first place years afterwards. And he was the only witness to speak of the insult, I don't know how it's pronounced, magus or magus, fire worshipper. Although we know the OTP doesn't rely on that evidence in their brief. Over the course of at least 2 days, at least 177 predominantly 4 males, including approximately 7 children between the ages of 8 to 12, were detained at Mukjar police station. So asserts the OTP at paragraph 416 of their brief. It's P129's evidence of children as young as 8 years old that's relied upon and yet is uncorroborated by other witnesses. As is his evidence that Ali Kusheb severely injured a young boy aged 9 to 10 who was sitting near Umda Yahya Ahmad Zaruk by striking him on the head with a sharp end of his axe, paragraph 422. We submit that such a brutal, such a horrific assault on a young boy would be memorable. It would be one of the more memorable brutalities to occur at Mukjar. It's remarkable, therefore, that P129 is the only witness to have spoken about it. An anodyne detail may have escaped the attention of some witnesses. It may be that the prosecution would say that with the passage of time, certain memories slip from, certain recollections slip from a witness's memory, and we understand that. But we say that an assault such as this on a child of that age just doesn't fall into that category. And we say that without corroboration, the trial chamber's approach should be a very cautious one. It's this witness, 129, who testifies to Kusheb striking Sheikh Abdallah Ahmad Hassan on his head with an axe, severely wounding him. Also striking Umda Muhammad Umar Ahmad Zaruk and Sheikh Ahmad Mohammed Barbai, all referred to at paragraph 420. He's the only witness cited by the OTP in their brief of these assaults. Uncorroborated, and therefore evidence that must be treated with the very greatest caution. P877 was a witness at Mukjar. We provide written submissions on his reliability at paragraphs 490 to 493, 502, 503, and 520, and I'm not going to repeat those. There's one feature of his testimony covered by the OTP in their brief at paragraphs 471 to 72, which deal with 877's account of going to see Ali Kusheb at his pharmacy sometime after his release. We say that that is an account entirely lacking in any plausibility. We accept that it could be plausible that out of curiosity, out of a desire to know the truth, a person who had been mistreated would want to go to the pharmacy and see what he can see about the owner of the pharmacy, to see if the rumors were true, that his tormentor owned that pharmacy in Garcilla. What's wholly implausible, we say, is that a witness would have such scant regard for his own safety and security as to, go into the lion's den and to speak with Kusheb for 5 minutes. We say that is utterly implausible. The danger of being recognized would be too great. His actions were so foolhardy, so imprudent, so unnecessary that no credit can be given to his account. Uncorroborated, that evidence, of course. And the fact that this account is so implausible, so lacking in any credibility, creates doubts, even significant doubts, over the entirety of B877's evidence. And the doubts that exist, we submit, specifically relate to danger of contamination of other evidence, of other witnesses' accounts, given P877's particular standing in his community. I won't go into more detail, but his is evidence that must require, we say, corroboration. Where there is none, where he's the only witness to speak of specific features of the Mukhtar events, Your Honours should be very slow to accept his evidence. I'm aware of the time. I'm going to pass over some other points I had to make. P931, the final witness I want to discuss relating to Mukhtar crimes, another insider who demonstrated the clearest animus against Mr. Abd Al Rahman. We explain this at paragraphs 139 to 140 of our brief. And in addition, this is a witness who registered himself on a list of rebel volunteers, opposition volunteers. This is a convenient point to address Your Honour's question 25. You ask, some prosecution's witnesses are linked with rebel movement. How should the chamber take this into consideration? Let me briefly deal with that now, if I may.
Question was that you were saying the chamber should take it into consideration.
Yes.
And the question was how.
Yes, absolutely. At paragraph 173 of our brief, we deal with this. Your Honour, we refer to the case of Ptolemyr before the ICTY. I'm just going to cite from Ptolemyr. It's the trial judgment, paragraph 37. The testimony of persons involved in a bitter armed conflict is often coloured by experiences and attitudes arising from that conflict. The Chamber is aware of the general tendency of witnesses associated with a party to a conflict to give testimony that supports its perceived interest. Your Honour, here we have a situation where the rebels are a party to the conflict against the government of Sudan. They were the enemy of the government of Sudan, and the government of Sudan were their enemy. Each side fought the other. They killed each other. Inevitably, this creates animosity between the two sides. And we say that this must be particularly acutely the case when one side, the government of Sudan, acted, and we accept, in a particularly brutal way. The levels of animosity must be inevitably high. And there will then be a natural inclination, we say. It's really just a question of human nature. For a witness to provide evidence that places the enemy in as negative a light as possible, and to place the side that they're on in as positive a light as possible. And really, it just stands to reason, we suggest, that it's a relevant factor for Your Honours to take into account, because it can impugn their objectivity and therefore impact their credibility. It's really nothing more complicated than that. Passing now to witnesses of the alleged crimes. There's witness P643, a witness associated with a political party, and an important witness going to the issue of Abd Al Rahman identifying as Ali Kusheb. The prosecution deal with or cite to P643 in paragraphs 12 to 15. Mr. Lauchi will cover this in much more detail tomorrow. We address 643's credibility at paragraphs 142 to 144 of our brief, but I mention him here to recall that he had a close association with another troublesome, incredible witness in P878. His association with 878, hugely hostile, dishonest, we say significantly taints his own evidence. You'll recall that he gave his opinion at one point as to why it is that Ali Kusheb was appointed as Agid al-Oghada, because as a retired army officer, he had a good command of warfare. Paragraph 138 of the prosecution brief. He's the only witness to give that evidence, as cited by the OTP. And I'd also invite Your Honours to look at footnote 498 in the prosecution's brief, citing to transcript 58. I was going to read it out, but I won't do. There's no evidence that Abd Al Rahman had any experience of command in warfare. That's the important point. It's experience as being in a position of command, combat command. He was, for the majority of his time in the army, a medical assistant, a nurse. That is all. P643's ability and willingness to engage in the most wild speculation untroubled by the lack of any facts, demonstrates that Your Honours must be extremely cautious before attaching any weight to his evidence. And in the same vein, really, 643, his evidence was enormously founded on hearsay, and sometimes hearsay at multiple removes. At paragraph 556, the OTP of the OTP's brief, they address what he heard about Genef's arrest and death, what he heard later on, paragraph 608 of the OTP's brief, what he heard about the deaths of Unda Kindiri and Unda Kamis. Elsewhere in the OTP's brief, what he heard about killings in Delej, what he heard of a report made about those killings. Your Honour, we urge you and your colleagues to be extremely cautious about what he says when reporting hearsay at one or more than one remove, because we say that he's a witness prepared to speculate, that he's an unreliable narrator. P994 was an inside witness to the Delej crimes. We say he was not credible. I'd refer Your Honours to paragraphs 566 and 568 and paragraphs 151 to 153. There was, this was yet another witness who demonstrated a striking difference between his willingness to provide an account when examined by the prosecution and his evasive demeanour under cross-examination. His cross-examination turned into an avalanche of I don't knows. Blood from a stone, that witness. And Your Honours may very well conclude that he was not, in the circumstances, an objective, disinterested witness whose motivation was to come and to do his best to tell the truth. He's the only witness to have overheard, or to claim to have overheard Ali Kusheb say to Unda Kindiri, whilst detained at Delej, "This is your last day on earth. Get ready for the doomsday." Paragraph 543 of the brief, and in fact, a memorable enough piece of evidence that was mentioned yesterday during the prosecution submissions. He's the only he's the only witness cited to by the OTP at paragraph 551 of their brief to have heard Ali Kusheb say to Genef, "Do you recognize me?" And Genef allegedly replying, "Yes, you're Ali." The source is cited at footnote 1788 do not in any event support that assertion, we say, and we'd invite you to look at that site carefully. The last witness I want to talk about before handing over is P883. Our credibility submissions on him, including contradictions and inconsistencies, are in our brief, starting at paragraphs 145 to 148, 458 to 460, and 569 to 574. He is heavily relied upon by the prosecution in regard to the Delej crimes, but you'll recall that he simply wasn't present. His purported knowledge of Delej comes from other sources. And yet that didn't stop him being relied upon to give a great deal of uncorroborated evidence of background. And the OTP clearly believe that he's an important witness because they rely on him heavily in their brief. For example, paragraph 169, relating to a delegation of high-ranking officers visiting Delej. applauding the role that Ali Khrushchev was playing, the fact that he mobilized the Janjaweed. This is a witness who recalled an incident at a particular location, observing Ali Khrushchev handing his Thuraya satellite phone to a colleague, and that act created a great deal of annoyance, because that latter person's commander was being put through to him by Abd Al Rahman. The arrest, detention and release of Umda Kindiri, Kamis and Jenef, and the arrest and detention of Umda Suleiman, paragraph 522, citing only to this witness. P883 was the only witness to suggest that Ali Khrushchev killed Jenef at an execution site near the horrors of Soja, rather than in or near the police station. The only witness to testify that the Delej operation was not under the direct command and supervision of the SAF. Paragraph 657 of the prosecution brief, explaining that the decision to carry out an operation in a village or area was made by the SAF, but that the operation itself was then carried out by the militia or Janjaweed. Uncorroborated. And the only witness cited by the OTP, paragraph 578, of the reburial of persons outside of Delej several months after the killings. So we have made very full written submissions on P883's lack of credibility in our brief, but in sum, a witness remarkable for just how much of his testimony is both indirect hearsay evidence and is wholly uncorroborated. Can I just turn my back for a moment? Your Honour, we have fairly full submissions on the issue of asylum, and we've prepared a PowerPoint. But with Your Honour's, it's ready. But with Your Honour's leave, it may make sense to deal with it tomorrow, if we may.
That's fine. That's one of our questions, right?
It is.
The relevance of the asylum.
25.
Well, as I have said about 4 times now, but I repeat, anything that comes from a judge's question, only if you feel you have sufficient time to deal with it on top of what you want to deal with, need you do so, we will deal with them all at the end.
Yes, we're grateful. Yeah. And can I say that I'm sure I speak for the prosecution as well. Your questions have been incredibly helpful, because it's always useful for a party to know where the jury, where the judges are coming from, what they're thinking of. So we found it an incredibly useful exercise.
Well, thank you very much. The reason is from my own previous experience as counsel of having the judges suddenly spring questions on you and having to ask for an adjournment and come back the next day.
Yes.
All right.
Yes,
that's fine.
Even worse is a bench that sits stony cold, silent, and without giving any indication of what they're thinking. So we're grateful.
Right. Yes.
Actually, I think that yes, I'm going to deal with other matters tomorrow, I think. You ready to? Yeah, this is a convenient and I can even say natural moment to hand over to Madame Mathilde.
Yes. I think this is the first time we've actually heard from her.
Your Honour, the presiding judge, the Honourable Bench, I will only address the question of crimes against humanity.
Miss Mathieu, you will have to slow down. You must have seen the messages when Mr. Lauchi was speaking.
Yes,
The interpreters couldn't keep up.
sure.
So try and keep it at a slowish pace.
J'adresserai seulement la question
I will
des
only
crimes
address the
contre
question of
l'humanité
crimes against
en
humanity
évoquant
with particular reference to certain aspects of the evidence relating to the knowledge and nature of the target civilian population, as well as discrimination for the crime of persecution.
Votre chambre
The
devra
chamber will
déterminer
have to
si
determine
une
whether
attaque
a
de grande
large-scale
ampleur
attack
était lancée
was
contre une
launched
population
against
civile au
a
Darfour,
civilian population in Darfur, Wadi
dans les
Saleh,
localités de
in
Moudjar en
the
2003,
localities of Mubjar in 2003
et en
and
application de la
2004,
poursuite
in
d'une
application
politique
or in furtherance of a
d'État.
state
C'est
policy,
l'article 2A du statut.
Article 72A
La
of
thèse
the
du bureau du
statute. The
procureur est que
OTP
les actes
argues
incriminés
that the
s'inscrivaient
act
dans
in
le
question
contexte
was
de cette
part of a
attaque
widespread or
à
systematic
caractère
attack
généralisé ou
against a
systématique
civilian
population civile.
population.
Pour que l'accusé soit
For
reconnu
the
coupable,
accused to be found
il
guilty,
faut la preuve
there
de
must
la
be
connaissance
evidence
de la
of
circonstance
knowledge
de
of the
ses
fact
s'inscrivait
that
dans
his
le
actions
cadre
were part of
global
an
de
overall
cette attaque
framework of this attack
conçu par la
conceived
politique
by
d'État.
state
Votre
policy.
jurisprudence
See,
y fait référence. Je vous
I'm
renvoie notamment au
referring
jugement
to
Katanga
the
sur ce point.
Katanga judgment on this point,
La chambre de jugement, la chambre préliminaire
and
Katanga dans la
Katanga
confirmation des
pre-trial
charges.
chamber confirmation of
Et également
charges, and
le TPIR,
also
le
the
jugement
ICTR
Kaishema
Kaishima and
Paragraphe
Ruzidana
133 à
judgment,
134.
paragraphs 133,
Nous avons
134,
noté dans les numéros 29,
and it's
23
in number
et 43.
29, 23, and 43 in our list of
Le
materials.
procureur allègue
The
donc que la
prosecutor
population
therefore
civile était la cible de
alleges
la
that the
politique
civilian
d'État
population was the
menée
target
par
of
les forces
the
du
state policy
gouvernement du
carried out by
Soudan
the forces of the
en 2003
government of Sudan
et
in
2004
2003 and
avec le soutien
2004
des Janjaweed.
with the support of the Janjaweed.
Il infère
He
l'objectif
inferred
principal
the
de
main
l'attaque
objective
contre
of the
une
attack
population
against a
civile
civilian
sur
population
la base
on
du
the
nombre de
basis of the
victimes,
number of victims,
composition de la
the
population,
composition of the
la
population,
façon dont
and
les
the
événements
way in which the
se seraient déroulés.
events were alleged to have
C'est là au paragraphe
unfolded.
93
Paragraph
de son
93,
mémoire.
OTP closing
À
brief.
cette fin,
Now,
se
to
base
this
notamment
end, he
sur nombre de
relied
localités qui ne
in
font pas
particular
partie des
on a
charges.
number of localities that were not part of the
À chaque fois,
charges.
dans les localités
On
concernées
each indication,
directement,
in the
les
localities
charges.
directly concerned by the charges,
que ce soit
whether
à
in Kudum,
Bindisi
Bindisi, Mukja,
et Délègue.
and Deleg,
Nous estimons
we
que le
consider
procureur
that the
n'a pas
prosecutor
apporté la
has
preuve
not
suffisante
provided
que
sufficient
Abd Al Rahman
evidence
avait
that
la
Mr. Abd Al
position
Rahman had the
d'autorité,
position of
forte
authority
influence
or
du
strong
seigneur
influence of the senior leader of Janjaweed, enabling him to interact with knowledge in the implementation of state policy.
La preuve au
The
dossier nous a montré
Evidence
l'existence
of file
d'une
show the
hiérarchie,
existence of
d'une
a hierarchy
organisation
and
politique,
a
militaire
clearly
et
defined
administrative
political,
étatique
military,
clairement
and
tracée.
administrative organization.
Toutefois,
However,
dans une certaine
there is a
nébulosité
certain
lorsqu'il
nebulousness
s'agit
or lack
des
of
liens
clarity when it comes
de
to the
rattachement
alleged links
supposés
between
existants
the
entre
accused
l'accusé et le
and the
système de la
system of
politique
state
mise en
policy
place
implemented
par les forces
by
armées
the
globales
government
du gouvernement
of
du Soudan.
Sudan's overall armed
Nous ne
forces.
soutenons pas que le
We do
droit
not maintain that the
requiert
law
que
requires
soit
the
membre
perpetrator to
officiel
be
de
an
l'appareil
official
d'État.
member of the apparatus of
Mais
the
la preuve
state,
versée
but
ne
the
suffit pas à conclure,
evidence
au-delà de tout doute
adduced is
raisonnable,
not sufficient to
que Monsieur
conclude
Abd Al Rahman
beyond
était un chef
reasonable
militaire
doubt
lié à
that
l'apparatus
Mr.
et à
Abd Al
sa
Rahman was a
politique.
military leader linked to the apparatus and the
Il n'a pas été
policy.
prouvé qu'il était un
It
chef
has
senior
not been
d'une
proven
milice
that he was a
identifiée,
senior leader of a
organisée,
militia
affiliée à cette
that is
politique.
organized to this effect.
Au paragraphe
In paragraph
398
398 of the closing brief of the OTP, the prosecutor contends that in Mukjar, Mr. Abd Al Rahman gave orders to the Mukjar police commander to arrest and register the men coming from Sindhu. He solely relies on witness P0905, whose credibility is questioned by us. Counsel Edwards spoke to you about this witness just a moment ago. In paragraph 481 of his briefs, the prosecutor also told us that the witness P0984 had heard Ali Kushaib tell Toshem, the Mukjar commissioner, the highest local authority, that he only received orders from Minister Harun. At the same event at which the two were still talking, Ali Kushaib is said to have ordered him to hand over the detainees to be taken to Zilingay. Now, there is more than reasonable doubt about the credibility of this testimony, according to which the highest local authority, Commissioner Toshen, submitted to Ali Kushaib. Now, it is hard to believe that, given Commissioner Toshen's hierarchical position, he could have been subordinate to Ali Kushaib. The OTP asserts that Ali Kushaib had such superior authority, but its origin has neither been identified nor proven. Now, even assuming that a state policy has been proven, the connection and knowledge of Mr. Abd Al Rahman and or Ali Kushaib with its implementation has not been established. We have set out in our written submissions the lack of credible, reliable, and too often contradictory evidence to draw the unreasonable conclusion that the person known as Ali Kushaib was present at various meetings and speeches, including in the presence of Harun, at which the state policy of attacking the Furs was allegedly set out. We refer to paragraph 677, 685 of our closing brief. In Mukjar and Delek, more specifically, the defense argued that the prosecution had not adduced sufficient evidence that the accused knew that the civilian population was the main target of the attack against the predominantly Fur population, and that it was part of a more general or systematic attack on state policy. Now, this is also relevant to the target of the criminal plan pursued and alleged as a direct coaction for Mukjar and Deleg. The evidence on the record suggests that rather than the predominantly Fur civilian population, it was in fact those suspected of being rebels or supporting the rebellion who were targeted. In those places, from the point of view of those responsible for the arrests and detentions, it was a matter of carrying out a specific operation on the order of the local authorities, in particular the local security committees, which had identified the suspects on the basis of information gathered by military intelligence. See paragraph 468, footnotes 1795 and 1796 of our closing brief. The civilian population refers to a collective population as opposed to individual civilians, and the prosecutor must prove that targeted collective quality of the population in these localities. The trial chamber in the Bemba case tells us, and I'm quoting, the prosecution must in fact establish that civilians were targeted in the course of the attack in such numbers or in such a manner so as to convince the chamber that the attack was directed at the civilian population and not at a limited number of specific individuals. The civilian population must be the primary and not the incidental target of the attack. Judgment, Trial Chamber, Bemba, paragraph 153, number 33 of our list of materials. Also referred to Katanga Judgment, paragraph 1104, number 29 of our list. Now, to necessarily link targeted arrests to a broader campaign against the civilian population would be to ignore the primary objective of these arrests and detentions. Counterinsurgency, which consisted of putting an end to the rebellion in the region. These specific circumstances must also be reflected in your assessment of the state of mind of the perpetrators of the crimes in relation to the mens rea required by Article 30 of the statute. Now, whether or not there was a widespread or systematic attack resulting from state policy will depend on your assessment of the evidence on the record. The acts committed against civilians and or people outside the hostility suspected of links with the rebellion in Mukja and Delek were not part of such a policy. In any event, it cannot be assumed that the accused was aware of them. He was not part of the overall organizational apparatus in any way whatsoever. The LRV reminds us in paragraph 216 of the closing brief that at the beginning of 2004, the population of Mukja multiplied due to the arrival of large numbers of people fleeing attacks. This population increased from 7,000 to 41,216 people. This means that there were more than 30,000 new arrivals in Mukja. The evidence shows us that the arrest operations carried out in February 2004 at checkpoints on the outskirts of the city by the Sudanese government forces were targeted in time, place, and number in relation to the massive influx of people. The aim was to search for and arrest potential rebels who might be hiding amongst the arriving population. Witness P0547 stated that the rebels were dressed in civilian clothing. Those responsible for the targeted arrest and subsequent detention used lists drawn up by the security committees on the basis of information collected by military intelligence to search for rebel elements hiding amongst the arriving population. See paragraph 468 of our witness statement P0990, P0129, P0922, P0769. Neither all the furs nor all the fur men were targeted and arrested at Mukja and Deleg. These elements are also decisive with regard to the crime of persecution and discriminatory intent. In paragraph 230, the prosecutor relies on the testimony of P0675 to assert that at Mukja, the men arrested had no weapon markings on their shoulders and therefore were not rebels. Witnesses P0675 and P0990, in fact, tell us that those responsible for the arrests were looking for men, in particular with weapon markings. See our closing brief, paragraph 468, and we do not maintain that this was the only targeting method. Also, in paragraph 232 of the closing brief, the prosecutor maintains that witness P0931 was targeted because he was fur. Yet his testimony shows us that he had registered as an opposition volunteer wanting to join the rebellion. His targeting did not necessarily appear to be ethnic, but motivated by the search of men likely to provide military support to the rebellion. See paragraph 168 and paragraph 139 of our closing brief. The prosecutor further alleges that women and children were taken to the Mugja municipality building, the Mugja locality building, to be detained during these arrests. Paragraph 230 and 250 of the prosecution's final brief. These facts and circumstances at the Mugja locality building are not mentioned in the decision on the confirmation of charges of the pretrial chamber 2. There is no mention of the detention of women and children and the presence of Mr. Abd Al Rahman as the charges were confirmed. We submit that this is not before the chamber. In addition, in paragraph 408 of his closing submission, the prosecutor maintains that 4 police officers had also been arrested and targeted on suspicions of supporting the rebellion. Mr. Abd Al Rahman allegedly arrested and confiscated the weapons of the 4 members of the police force. He relied on a single piece of evidence, witness P0877. Other police 4 witnesses, P0992, P0976, who were supposed to corroborate these claims, did not appear in the end. No other detained witnesses or other witnesses present at the Mugja police station, such as P0913, P0905, P0984, and P0931, mentioned the presence of people in police uniform or members of the 4 security forces being arrested or detained. In reality, it was the members of the security forces, including those belonging to the 3rd tribe, who made the arrests. Paragraph 468 and 480 of the defense closing brief. The prosecutor's assertion that the conscription of men into the PPF police made them suspect is unconvincing. On the contrary, it was those who refused to enlist in the government security forces who were under suspicion. If, in the minds of those responsible for the arrests and detention, all 4 men had been equated with rebels, the arrests would have been made in mass numbers, and it would primarily have concerned the 4 members of the PPF police. For the record, as indicated in paragraph 375 and 303 of our closing brief, Jafar Abd Al Hakam, Commissioner of Ghasila and head of the Security Committee, was fur. 294 police officers joined the ranks of the police in February 2004. Paragraph 445 of our brief. Witnesses P0984 and P0913 testified that this enlistment was based on the fear of being detained if they refused. This may also demonstrate that only those who refused to enlist could be suspected of supporting the rebellion. See paragraph 445, defense closing brief. Witness P0913 on this issue. With regard to delay, the evidence on the course of events shows us that the rebels or the people suspected of supporting the rebellion were the specific target because they were on the list. Checkpoints were set to arrest very specific people whose names and towns were on the list. Paragraph 649, defense closing brief. The suspicion did not spare the Umdas and Sheikhs who were arrested when there were suspicions that they were supporting the rebellion. I'm referring you to witness P0883. For the decision to arrest him was taken by the Ghasila Security Committee chaired by Jafar Abd Al Hakam. The prosecutor further alleges that young boys and people over the age of 60 were also targeted. Witness P0907 is quoted by the prosecutor in his briefs in support of this allegation, paragraph 240, footnote 822, but he also stated that the same witness We spoke about this on the first day. He also stated that the elderly people, the children, were not taken to the police station. They let them go. They took me and my brother-in-law. He added, when we were taken to the police station and arrived there, the children and elderly people were released. T transcript 096, French version, page 14. And transcript 094, French transcript P32. Witness P0651, who was 14 or 15 years old at the time of the events, he told you that he had not been afraid of being arrested because he had a card showing that he was a lower secondary school pupil, which protected him from being arrested because he was not an adult. Although some witnesses mentioned the age of the people as boys, it should be borne in mind it's often difficult for witnesses to be able to assess the age of people. Could you ask the council to slow down, please, Your Honor? We maintain that the main target of the...
The interpreters are begging you.
Oh, sorry.
Thank you, Your Honor. We maintain that the main target of the arrests was not the entire male fur population of these localities, and the contradictory and unreliable evidence does not make it possible to determine that Ali Kushai, who took part in the arrest and detention at Delayed Police Station on the 5th of March 2004. I don't know if I've got some more time. Can I continue? Now, I'm now turning to the crime of persecution, which requires specific discriminatory intent. Now, this encompasses a series of acts committed against the civilian population when committed with the specific discriminatory intent of the perpetrators. The perpetrator must have targeted a person because of their membership of a group identity, and this targeting must be based on enumerated grounds, in this case political, ethnic and gender grounds for Mukjar and Taleg. The extreme severity of the crimes does not per se demonstrate the specific discriminatory intent. The prosecutor submits that the fur men in these localities were perceived as supporters or associates of armed rebel groups, paragraph 229, OTP closing brief. This perception does not necessarily make any exaction politically discriminatory. There must be evidence of the specific intention of the perpetrator to have committed his act for this discriminatory reason, paragraph 666, defense closing brief. The crime of persecution allegedly committed against a group of men, furs, or assimilated to this tribe on the grounds of gender has no basis in this case. Here again, evidence of the specific intent is required. Proof that the perpetrators were motivated by this gender discrimination because of the theory of the social role presumed to be expected of any fur man perceived as an enemy in wartime in 2003 and 2004 in Sudan. If women had been enemy combatants in that war, there would be little doubt that they would be enlisted, arrested, and detained because they were perceived as rebels by the perpetrators of these arrests. Witness P0020, quoted in paragraph 239 of the defense briefs, explains the form of participation in the rebellion. Above all, no evidence of discrimination, sexual violence, humiliation, or ill treatment of any kind whatsoever on the grounds of gender emerged from the file. Now, since this artifice does not hold up, the prosecutor built his case on other discriminatory grounds. Intersectionality of grounds linked to political and ethnic grounds. The allegation of discrimination on the basis of gender in this case is no way in no way corresponds to the reality of the facts in the context of the Sudanese society in 2003 and 2004. And this concludes my presentation on background elements and persecution. I'm sorry for the speed of my intervention, and I'd like to thank you.
I don't know ideas, but French is just that much faster than English. Yes, Mr. Edwards.
Your Honor, we've got 5 minutes.
Yeah, but I think, did you want to do something in 5 minutes?
I can briefly outline where I'm going next, if I may.
Yes, right.
Every minute counts, really.
Yes.
Yeah.
Well, I mean, the fact that we rise now, it doesn't affect your time.
Yeah. I'm in Your Honour's hands.
I think, because there's just one thing I want to ask you, and reflect overnight. We gave you leave for your client, the accused, to make an unsworn statement as part of your final addresses under Article 67(1)(h). The authorities say that's not evidence. So what I'd like you to reflect and address us on is, if it's not evidence, so what is it? Mr. Larchi, I think I'll say tomorrow morning, because I know Judge Alipino Gonsu has got to go, but if you can tell me tomorrow morning how we're supposed to deal with it, then I'd be very grateful. Unless you can do it in one sentence.
Je peux le faire en une phrase.
I can do it in one sentence. Mr. Abd Al Rahman would like to take the floor at the end of the trial, and we would like to communicate this request. Of course, it does not constitute evidence.
That really is not very helpful. Can you see? Can you think about it?
Je ferai
and see
mieux
if you
demain.
can be more help tomorrow.
I'll tell you tomorrow.
Thank you. Yes, very well. We'll adjourn then, please, until 9:30 tomorrow morning. Oh, all right.
Oh, no, just very quickly, Your Honors, and I don't mean, sorry to slow you down. I just wondered if there's any, within the questions, anything in particular you would like us to focus on, because by my count, we went through 8 of them on the prosecution side, and whether there's anything in particular you think we should take a look at. Because what we tried to cover were 1, 3, 5, 6, 14, 18, 20, and 23. So
Yeah.
we just wondered if you have any further direction. As Mr. Edwards said, we'd be happy to focus.
Yeah. Yes. Did you deal with question 13?
No.
Yeah. I think that may be one of the more important. And 15. I'll say we did get a bit carried away. 26 and 28.
All right, thank you. We will try to be ready for everything, but we'll take a close look at those.
Okay, and I have a couple of extra questions. Sorry, I'm apologising to my colleague. Which, firstly, this is for the defence. If you're not running duress, as Mr. Nichols says, you haven't pleaded duress, so I'm assuming you're not running duress. No, and I see Mr. Light shaking it. Then what's the relevance? Can you explain tomorrow, perhaps, what the relevance is of what's in your, for example, in your paragraph 261 about the death penalty and the disobeying of orders? Because it's a bit difficult to see what it goes to if it doesn't go to a form of duress. And the second is this, and it's really for the prosecution. Was there any evidence given as to what injuries Mr. Al Rahman suffered in the attack on him in whenever it was in 2013?
Yes, at least in the form of articles.
Yeah,
And
well, that's
one
why we
witness-
did say where
and
the
one witness
injury
who-
was.
I would have to check one witness who
Yeah.
was familiar, but there definitely were, broadly speaking, yes, what his injuries were.
Okay, all right. Well, if
We
you could
can
just
look
remind
at-
us
yeah.
of it. Well, yes, thank you.
Thanks.
Yes, so again, we'll adjourn now till 9:30 tomorrow morning.
All rise. We will away.